to take a motor vehicle that was still at the police station. My lady, a motor vehicle that belongs to one of the respondents. That brings me to the fact of what I need to indicate. It shows their cooperation and the fact that they are not a flight risk. They were outside and they went to the police station by themselves. My lady, it is beyond common sense that someone who is being claimed as a murderer can come back to where he is being sought for. My lady, also to note, under the same paragraph, I believe, let me just have a look at it. We have only the benefit of the miscellaneous at this moment. My lady, there's a paragraph under the affidavit, and it has also been acknowledged by the DPP, that the main persons of interest are police officers, key police officers. Your Honor, these are civilians who only happened to be at the scene when that occasion happened. My lady, putting them under custodial for another 21 days as civilians who do not have the power to tamper with any investigation will be unfair and unjustified. My lady, further to that, it has been indicated under the affidavit that there is a risk that the respondents might jeopardize with investigation. My lady, no evidence has been submitted in any way, either through attachment or by clarity under the affidavit. under prayer B, my lady, because I do not have a right of response after this, they would respond in a different way. Same time, but held under different police stations. And just for the record, there's another respondent that has been taken to a different court, totally, which shows the line in which the investigation is taken. But my lady, we are willing for them to be held at those police stations. However, this weekend we have faced a challenge, even speaking to our client, the first respondent. We cannot get proper instructions from him because apparently the police station have orders for him not to speak to us directly unless they have been brought to court. My lady, if that is the case, we pray that when he is held at that specific police station, we can get express orders for the advocates and the family to have a direct access, which is his constitutional right, anytime and upon a reasonable time, which I believe is 6 to 6, to have a talk with the first respondent. Also for purposes of his safety, which we shall be assured of. My lady, those are our humble submissions that we need this court to kindly accommodate us. Thank you so much, my lady.
Yes, we do have some brief submissions. You will also note that Council has indicated to the court that the respondents will be willing to be detained for 14 days. Okay. I'll start with the right to bail. The defense has submitted that right to bail is a constitutional right. And on our part, for the state, we do submit that yes, it is a right, a constitutional right, but it's not a right that cannot be limited. Your Honor, the Constitution provides for limitation of this right, where the state has demonstrated compelling reasons. It is our submission that the state, through the application that we have filed in court, will be able to show to this court that we do have compelling reasons to warrant the detention of the suspects at the police station. In response to paragraph number 9, as the defense has pointed out to the court, our paragraph clearly states that the respondents participated in the offense. So the averment that they did not participate is neither here nor there. We will also like to submit that it is true the respondents were arrested and were in the police cells in relation to a different case. It's not this case that is before you. They were arrested for having committed an offense of preparation to commit a felony, and what is before you, Your Honor, is a totally different case that relates to a murder charge. We also meet in connection to that the suspects, as we look at our affidavit, were arrested at the police station. So for that case, we are not aware if they have any fixed place of abode. For us, it is our submission that they are flight risk. We do not know their places of abode. We cannot confirm to this court that we know their fixed place of residence. We also submit to the court, Your Honor, that even though the respondents are civilians, we have pointed out that this is a complex case. It involves the participation of officers of the National Police Service, and these officers are likely to influence the respondents so as to interfere with the investigations that are still ongoing. Your Honor, back to the case that we have quoted, the Mwangangi versus public case, we do submit that the circumstances in that particular case were totally different from the circumstances that are before you now. Your Honor, with those submissions, we want to confirm that they have also not recorded their statements, and we require them to continue being detained for purposes of statement recording. With those brief announcements, we still reiterate our application that the respondents be detained for a period of 14 days to enable us now conclude our investigations.
You have considered?
Yes, we have considered.
So we can resume at 2:15 for a ruling. Just on 2:15.
So much agreed.
Just for clarity of the record, can it be officially indicated that the DPP has indicated that they have not recorded their statements?
I have noted that they have not recorded their statements.
Yes.
Yes, it's on record.
That's fine.
Okay. So you come back at
Mimi chap. Mimi yangu ni chap. Ndio ulize majina. So ulize majina. Kutumia.
Nimeona anachukua